May 3, 2023. Unit 9 Acquisitions and Conveyances. Ademption, Administrator. Adverse possession. After acquired title, bequest, codicil. Color of title, dedication, deed, devise. Eminent domain, escheat. Exception in a deed, executor. Formal will. Gift deed. Grant deed. Holographic will, Independent Administration of Estates Act. Intestate succession. Inverse condemnation. Marketable title. Pursterps. Police power, probate, Proposition 99. Quitclaim deed. Reservation in a deed. Sheriff's deed. Simultaneous death. Tacking on. Tax deed. Trustee's deed. Valid will. Warranty deed. Will. Ademption is a legal term used in the law of wills to describe what happens when property bequeathed under a will is no longer in the testator's estate at the time of their death. An administrator is a person appointed by the court to manage and take charge of the assets and liabilities of a decedent who has died without making a valid will. Adverse possession is a legal principle in the Anglo-American common law under which a person who does not have legal title to a piece of property may acquire legal ownership based on continuous possession or occupation of the property without the permission of its legal owner. After acquired title is a legal doctrine recognized in many jurisdictions which provides that when a grantor purports to convey or mortgage property to which they are not vested, but later acquires that title, it automatically passes to the grantee or mortgagee. A bequest is a gift by last will or testament, also known as a legacy. A codicil is a written amendment to an existing will, which must be dated, signed, and witnessed. Color of title refers to the appearance of a legally enforceable right of possession or ownership of a property, based on a written instrument or record that purports to transfer ownership of the property but, due to a defect, does not actually do so. In real estate, dedication refers to the conveyance of private land, either in fee simple or as an easement, for public use. The landowner can convey the property according to dedication, which means that the landowner surrenders the property for public use to the government. A deed is a legal document used to confirm or convey the ownership rights to a property. In real estate, a devisee is an individual who receives real estate property from another person through the latter's last will and testament. A devise is a disposition of real property by a person's last will and testament, to take effect after the testator's death. Eminent domain is the power of the government to take private property and convert it into public use, following the payment of just compensation to the property owners. Escheat is the right of a government to take ownership of estate assets or unclaimed property in the event there are no heirs or beneficiaries. An exception in a deed is a reservation of a property interest in the deed for the transferor. The transferor is explicitly keeping some part of the property being given to the transferee, such as an easement or a life estate. An executor is a person named in a will to oversee the process of wrapping up the testator's affairs after their death. A formal will is a typed and signed will that is witnessed by two disinterested parties. A gift deed is a legal document that voluntarily transfers title to real property from one party, the grantor or donor, to another, the grantee or don. A holographic will is a will that is entirely handwritten and signed by the testator. The Independent Administration of Estates Act, ACQUISITIONS, is a piece of legislation under the California Probate Code that was passed in 1987. The ACQUISITIONS outlines actions a personal representative can take to administer an estate without court supervision. Intestate succession refers to the legal process of distributing a person's assets after they die without a valid will or trust. Inverse condemnation is an action brought against the government by a landowner to obtain just compensation for a taking of property effected without a formal exercise of eminent domain. A marketable title is a clear and unencumbered legal right to a piece of real estate. Pursterps is a legal term used in the law of inheritance and estates. It is a designation made during estate planning in which beneficiaries inherit the estate by right of representation. Pursterps translates loosely to by roots or by branch in Latin. The police power is the basis for land use planning authority in the United States. Probate is the legal process of administering a deceased person's estate, which includes the collection of everything they owned when they died. Proposition 99 is an initiative statute that appeared on the November 8, 1988 California general election ballot, as the Tobacco Tax and Health Protection Act. A quitclaim deed is a legal document used to transfer ownership of real property from one party to another. Unlike a warranty deed, A quitclaim deed does not provide any warranties or covenants. A reservation in a deed is a legal term that refers to the retention of certain property rights by the grantor or seller. A sheriff's deed is a legal document that gives ownership rights in a property to a buyer at a sheriff's sale. Simultaneous death refers to the loss of life by two or more individuals concurrently or pursuant to circumstances that make it impossible to ascertain who predeceased whom. Tacking on refers to the ability of successive landowners to combine the time of their adverse possession so that the last owner can meet the required time period for adverse possession. A tax deed is a legal document that grants ownership of a property to a government body when the owner fails to pay any associated property taxes. A trustee's deed is a legal document that conveys real estate out of a trust. A valid will must satisfy three basic requirements to be a legally binding document. First, it must be voluntarily entered into and signed by the testator. Second, the testator must be of sound mind when creating the will. Third, the will must be in writing. A warranty deed is a legal real estate document that protects the buyer and ensures that the seller holds a clear title to the property, has no outstanding liens or mortgages, and there will be no future claim to the title of the property. A will is a legally binding document that outlines a person's wishes regarding the distribution of their property and assets after their death. Voluntary transfers of real property deeds before the statute of frauds. Title was passed by a voluntary ceremony known as livery of season. The parties would physically indicate transfer of title through the symbolic transfer of a clod of earth, a twig, or a key. It became common for unscrupulous individuals, using perjured testimony, to claim a transfer when in fact delivery of season had not taken place. The statute of frauds was really enacted to defeat this type of fraud. The statute of frauds requires that transfers of real property interests be in writing. The deed is the transfer instrument in a voluntary transfer. When the deed is properly executed, delivered, and accepted, it transfers title to real property from a grantor to a grantee. Requirements of a deed written. The statute of frauds requires that every instrument dealing in rights in real estate, other than a lease for 1 year or less, be in writing. Execution. The deed must be executed, that is, signed by the grantor. The grantee, who receives the deed, need not sign the deed. An attorney in fact may convey marketable title only if the power of attorney under which the deed is executed is acknowledged and recorded. Description. The property must be described sufficiently so that no doubt exists about the identity of the property being conveyed, and the boundaries must be positively located. Delivery. To transfer title, a deed must be delivered. The most important element of delivery is the intent of the grantor. Acceptance. To be valid, a deed must be accepted. Acknowledgement is made by a grantor before a notary public or another authorized person. The grantor acknowledges that the signing of the deed is the grantor's own free act. Between the parties, an unrecorded deed can convey good title. However, an unrecorded deed does not give constructive notice to the world of the grantee's interest. Types of deeds. Grant deed. The deed used most commonly in California to transfer title, the grant deed. Quitclaim deed. A grantor under a quitclaim deed transfers only the interest that the grantor has and makes no warranties of title. If the grantor has a fee simple title, then that is the title conveyed. If the grantor has only a life estate, then only the life estate will be conveyed. Warranty deed. Under a warranty deed, the grantor expressly guarantees a good title and agrees to defend the title and to be liable if the title is defective. Sheriff's deed. A sheriff's deed is given at execution of a judgment under a sheriff's sale. It transfers only the former owner's interest and contains no warranties. Tax deed. A tax deed is given when property is sold by the tax collector to the public for non-payment of taxes. After 1 year from date of purchase, the property is acceptable for title insurance. Trust deed. A trust deed is given by a borrower to a third party to hold in trust as security for a lender. Trustee's deed. A trustee's deed is given to the highest bidder at a non-judicial foreclosure sale on a deed of trust. Gift deed. Any deed where no valuable consideration was given is considered a gift deed. The deed is valid unless it was given to defraud creditors, in which case it can be voided. Revocable transfer. On death deed. This deed does not affect possession or ownership while the owner is alive. If not revoked by the owner, it transfers title to the beneficiary upon the owner's death without necessity of probate. Void and voidable deeds. A void deed transfers no interest whatsoever, even if a purchaser paid value and acted in good faith. The following would make a deed void: A forgery. A alteration. A the fact that the grantor is a minor. A the fact that the grantor has been declared insane or is entirely without understanding. A failure of delivery. Voidable deeds are valid deeds unless or until they are voided. The following would allow a deed to be voided. A fraud. A undue influence. A duress or menace. A the grantor's not being of sound mind, but not declared insane nor entirely without understanding. Reservation in a deed. A reservation in a deed gives the grantor a right that did not exist separately before the grant. For example, a grantor could reserve an easement over the property conveyed, retain a life estate, and retain oil and mineral rights, and so on. Exception in a deed. An exception withdraws part of the described property from the grant. For example, the grantor, after describing the deeded property, could accept the south 20 feet from the grant. Exceptions in deeds often use the word sans, which means without. Dedication. A dedication is a donation of land for public use. Because it is a donation, the donor receives no consideration. A user of land can acquire title to the land of another by adverse possession. The rationale is that property should be used productively and taxes should be paid. Several conditions must be met. The possession must be an actual occupation. A claim of occupancy can be based on the occupancy of a tenant of the person claiming the adverse interest. Possession must be open, notorious, and hostile to the true owner's title. Use must be under a claim of right or color of title. Possession must be continuous and uninterrupted for a period of 5 years. The adverse possession claim must include a certified record from the tax collector that the adverse user has paid all property taxes for 5 years. To obtain a marketable title, an adverse user either would have to obtain a quitclaim deed from the title owner of record or would have to commence a quiet title action to have the court determine ownership. The power of the government to take private property for the public good is called eminent domain and is set forth in the Fifth Amendment to the U.S. Constitution, as well as the California Constitution. The exercise of police power to protect health, safety, morals, and general welfare generally cannot be delegated, and it does not entitle an owner to compensation. Examples of police power would be enforcement of zoning ordinances or fire, building, and health codes. Proposition 99, Homeowner and Private Property Protection Act, prohibits the taking of an owner-occupied residence by eminent domain when the intention is to turn the property over to a private party rather than take it for public use. Inverse condemnation. If an owner is unable to use the property as a result of public action, an action could be brought for inverse condemnation to force condemnation proceedings. For example, if the construction of a new airport caused jets to pass 500 feet over the roof of a house, the noise might destroy the owner's peaceful use of the premises, and an action for inverse condemnation would be proper. Testate succession. A will is a testamentary declaration about the disposition of a person's property, to take effect upon the maker's death. A codicil, an amendment to a will, requires the same formalities as a will. A devise is a transfer of real property by will. A bequest is a transfer of personal property. Legacy refers to money. Types of wills. Formal will. A formal will must be signed in the presence of at least 2 witnesses who, at the maker's request, attest to the testator's declared will. A holographic will is handwritten by the testator. Non-cupative will. Oral, or non-cupative wills are no longer valid in California. Ademption. Disposition of property before a person's death revokes the portion of the will giving that property to a named beneficiary. When spouses die in a common disaster, simultaneous death, and there is insufficient evidence to conclude that one spouse survived the other, the estate of each spouse will be distributed as though each had survived the other. When a deceased leaves no will, the property passes to the deceased's heirs by the law of intestate succession. Escheat. If a person dies intestate and that person's representative is unable to locate an heir within 2 years after death, the Attorney General will bring an action to declare title to be vested in the state. Probate. Probate is the legal procedure that provides for the transfer of the real and personal property of the deceased, as well as the payment of the debts of the deceased. The person appointed under the will to serve as the personal representative of the deceased during probate is commonly referred to as the executor. If the deceased died intestate, without a will, the court will appoint a personal representative, commonly referred to as an administrator, to represent the deceased. Community property. If there is a surviving spouse, a 1/2 already belongs to surviving spouse. A remaining 1/2 goes to surviving spouse after decedent's liabilities have been paid. Community property with right of survivorship. If there is a surviving spouse, Surviving spouse takes entire property. The Independent Administration of Estates Act allows a private sale of property in probate without a court proceeding, allowing later bids. Living trusts. A living trust may be used in addition to a will. Under the living trust, the trustors generally transfer their property to themselves as trustees for the beneficiaries, who are usually the same people. By holding property in joint tenancy, property is automatically transferred to the surviving joint tenants upon death of one joint tenant, thus avoiding probate. Deed requirements include a writing, because of the statute of frauds, a execution, a description of the property, a delivery, a acceptance, a granting clause, a competent grantor, and a definite grantee. Unit Quiz 1. After a deed was signed by the grantor, the grantee made a slight unauthorized alteration that increased the size of the property conveyed from 600 acres to 620 acres. The effect of this modification was that a. The entire deed became void. b. Only 600 acres would be transferred because the alteration cannot pass title. c. 620 acres were transferred, but the grantee could be liable for damages. d. The grantor has 1 year to discover the forgery and void the transfer. Answer A. The entire deed became void. Alteration voided the deed. 2. Title transfers with a deed at the time of a. Delivery. b. Signing. c. Acknowledgement. d. Recording. Answer A. Delivery. 3. The most important factor in the delivery of a deed is a. The intent of the grantor. b. Physical conveyance. c. Possession. d. Recording. Answer A. The intent of the grantor. 4. After a man's death, a deed giving his home to a nephew is discovered in the same envelope as his will. The will, dated before the deed, gave the house to his church. Who gets the house? A. The church, because the will was dated before the deed. B. The church, because the deed was never delivered. C. The nephew, because the deed was dated later and thus modified the will. D. The nephew, because deeds have priority over wills. Answer B. The church, because the deed was never delivered. 5. Which deeds would fail to transfer title? A. A deed to John Jones using his stage name Mr. Marvelous. B. A deed made to Henry Schmidt and wife. C. A deed made to Henry or Henrietta Schmidt. D. A deed to Tom Brown, an emancipated minor. Answer C. A deed made to Henry or Henrietta Schmidt, not a definite grantee. 6. Acknowledgement is necessary to a. Deliver a deed. b. Validate a deed for recording. c. Have a formal will. d. Convey legal title. 316 Unit 9 Acquisitions and Conveyances. Answer B. Validate a deed for recording. 7. Which are characteristics of a recorded deed? A. It must be acknowledged. B. It is presumed to have been delivered. C. It provides constructive knowledge of the transfer. D. All of these are characteristics of a recorded deed. Answer D. 8. Which is a requirement of every valid deed? A. Acknowledgement. B. Dated. C. Witnesses. D. None of these. Answer D. 9. Which is a characteristic of a quitclaim deed? A. It conveys after acquired interests. B. It can convey a partial interest. C. It warrants that the grantor has not previously conveyed the property. D. It warrants that there is nothing against the property that the grantor knows about that has not been disclosed. Answer B. It can convey a partial interest, whatever interest grantor has. 10. What type of deed is received by a purchaser after a sheriff's sale? A. Limited warranty deed. B. Quitclaim deed. C. Sheriff's deed. D. Grant deed. Answer C. Sheriff's deed. 11. When you receive and record a gift deed, which could adversely affect your title? A. Creditors of the grantor. B. Rights of parties in possession. C. Prior unrecorded deeds given for valuable consideration. D. All of these. Answer D. 12. A grantor retained an easement over conveyed land. What is this called? A. A reservation. B. An exception. C. A codicil. D. An after acquired interest. Answer A. A reservation. 13. In obtaining title by adverse possession, it is not necessary to A. Live on the property. B. Actually pay taxes. C. Have open and notorious occupation. D. Have occupation that is hostile to the interests of the owner. Answer A. Live on the property but must occupy it. 14. Tacking on refers to A. An additional party to an agreement. B. Additionally acquired security. C. Adverse use of a previous or subsequent user. D. None of these. Answer C. Adverse use of a previous or subsequent user. The 5-year period is satisfied if an adverse user uses the property for 2 years and a successor in interest to the adverse user uses the property for an additional 3 years, tacking on. 15. Abel's property was taken by the city for a new civic center. Baker was Abel's tenant in the property and had 5 years remaining on an advantageous lease. Which statement is true of Baker's rights? A. Baker's only right is to 30-day notification. B. Baker has rights against Abel for the value of his lease interest. C. Baker has rights against the city for the value of his lease interest. D. Both B and C are true of Baker's rights. Answer C. Baker has rights against the city for the value of his lease interest. 16. Loss of value of remaining land caused by a taking under eminent domain is known as A. Inverse condemnation. B. The police power of the state. C. Severance damage. D. Exemplary damage. Answer C. Severance damage. 17. An owner's property was seized because it was used for drug sales. Which statement is correct? A. The owner is entitled to the fair market value of the property. B. If the owner is not found guilty of a felony, the property must be returned. C. Innocence of any knowledge of the use would be a defense against seizure. D. None of these statements is correct. Answer C. Innocence of any knowledge of the use would be a defense against seizure. 18. A codicil providing for transfer of real property is a N.A. type of deed. B. Amendment to a deed. C. Original government transfer. D. Amendment to a will. Answer D. Amendment to a will. 19. Alex's inheritance of a house from his uncle George would be called a bequest. B. Devise. C. Legacy. D. Dedication. Answer B. Devise. 20. Which is a requirement of a holographic will? A. Verbal disposition. B. Handwritten. C. Witness. D. Dated. Answer B. Handwritten. 21. Agnes sold her house and purchased stocks and bonds with the proceeds. Upon her death, a will was found giving her house to her best friend, Mildred. What is Mildred entitled to? A. The stocks and bonds. B. The value of the house at the time Agnes died. C. The price Agnes received for the house. D. Nothing. Answer D. Nothing. Ademption. Disposition of property before a person's death revokes the portion of the will giving that property to a named beneficiary, that is, ademption. For example, if a man's will gave a specific property to his cousin, but he sold that property before his death, the devise to the cousin would be revoked. The proceeds from the sale would go to residual beneficiaries and not to the cousin. 22. Alice and Jack, a married couple, hold all their property as community property. When Alice dies intestate, each of the couple's 5 children will receive a 1/5 of her property. B. 1/5 of 2/3 of her property. C. 1/10 of her property. D. Nothing. Answer D. Nothing. All community property to spouse if intestate. 23. A woman died intestate, leaving 1 living son and 2 grandchildren, by a deceased daughter, as her only living relatives. The disposition of her property would be A. 1/2 to her son and 1/4 to each of the grandchildren. B. 1/3 to her son and 1/3 to each grandchild. C. To the state by a sheet. D. None of these. Answer A. 1/2 to her son and 1/4 to each of the grandchildren. Grandchildren take by right of representation. 24. A will provided that all of an unmarried testator's estate would go to his only child. His child predeceased the testator, but the child left a spouse and 3 children. The estate would A. escheat to the state. B. Pass 1/3 to the spouse and 2/3 to the grandchildren. C. Pass 1/2 to the spouse and 1/2 to the grandchildren. D. Pass 1/3 to each of the grandchildren. Answer D. Pass 1/3 to each of the grandchildren. Inheritance is by blood. 25. The executor brought a bid of $190,000 to the probate court for approval. The court will not consider late bids less than A. $190,001. B. $191,000. C. $200,000. D. $209,000. Answer. C. $200,000. 10% higher on first 10K, 5% higher on remainder.